Good morning and welcome to another episode of Gough Square Live. This morning we are discussing the topic of corporate liability. We know that many of our viewers come from trading standards services from around the country, so the talk is a little skewed to take that into account, you lucky people. But the principles we're discussing are equally applicable to those investigating from other perspectives, or indeed to those advising or defending corporate entities. Corporate liability is a hot topic. There is significant political concern that the law does not fully hold corporate entities to account for criminal acts, as there is often difficulty in pinpointing responsibility within organisations, where decision making can be dispersed, as stated by the Law Commission in 2022. Nevertheless, corporate entities are regularly prosecuted up and down the country, with significant financial penalties resulting. The $7.5 million for used-by date offences in Birmingham instantly springs to mind. This morning we will be addressing four topics. 1. What is a corporate entity? 2. When is a company potentially liable for the acts of its employees? 3. The liability of company directors. And 4. Pitfalls and corresponding tips when dealing with the investigation and prosecution of corporate bodies. So, Sabrina, what is a corporate entity?
Well, when we refer to corporate entities, we're most frequently talking about companies. And where a statute creates an offence for a person, that expression includes companies. If you need any support for that or encouragement, look to Schedule 1 of the Interpretation Act 1978, which defines a person to include a body of persons corporate or unincorporate. So where an offence is committed by a person, there is at least the possibility of prosecuting a corporate. On the other hand, where reference is made in the statute to an offence being committed by an individual, that does not apply to corporates. And indeed, there may be offences which are specifically created for corporates. A good example of this are the offences created by the Offensive Weapons Act 2019, which applied to delivery companies in relation to corrosive products and bladed articles.
So whether a company is potentially liable requires a careful analysis of the offence under investigation. Broadly speaking, however, there are three principles governing whether a corporate body may be liable for a criminal offence committed by those acting on its behalf. The first, whether the offence specifically provides for such liability. Examples are corporate manslaughter or the Bribery Act offences. They expressly relate to corporate bodies. The second is vicarious liability, where the offence imposes strict liability without proof or fault upon companies through the acts of its employees. And the third, the identification doctrine, where the directing mind and will of a corporate body can be shown to commit the offence. Given our time limit today, and you know how much we love time limits, we've even done talks on them. Just look to the YouTube site. We're going to concentrate on vicarious liability and the identification doctrine. So, many regulatory offences are of strict liability, meaning that if the actus reus of the offence, for example the supply of unsafe products or the sale of knives to those underage, can be properly attributed to the company, even if it was an employee without any directing mind or will of the company will, on the face of it, be liable. The offences do not require the proof of any mental element on the part of the company. In short, the master is responsible for the acts of the servant done in the course of employment. In practice, our experience is that it is rarely difficult to attribute to corporate bodies the actus reus of strict liability offences. Great, we hear many of you collectively think, but remember, strict liability regimes are usually and necessarily tempered by the availability of due diligence defences. And when investigating corporate entities, it is essential to follow that line of inquiry before making charging decisions. What about the identification doctrine, Sabina, when the offence in question requires a mens rea or mental element to be proved?
Well, for an offence requiring proof of mens rea, so the mental element, a company will only be guilty if the mens rea can be attributed to someone who is the directing mind or will of the company. So normally you'll be looking at the board of directors, the managing director, and perhaps other senior officers of the company that carry out the functions of management and speak and act as the company. But the courts have historically avoided an overly restrictive approach, so don't be afraid of casting the net beyond named directors in appropriate circumstances. So we've dealt with direct liability of companies where offences are created specifically for corporates. We've dealt with vicarious liability of corporates. The final big heading is directors' liability. It's needed so individuals can't hide behind the corporate veil, and it mitigates, to some extent at least, against phoenixing, so the law can keep up with individuals who create companies, offend, wind up the company, and then repeat. Those offences are expressly created in statutes, and what you're looking for are the consent, connivance, and neglect provisions. The most familiar consent, connivance, and neglect provision is likely to be Regulation 15 of CPUT, the Consumer Protection from Unfair Trading Regulations. This provides, and I quote, where an offence under these regulations are committed by a body corporate is proved, A, to have been committed with the consent or connivance of an officer of the body, or B, to be attributable to any neglect on his part, the officer, as well as the body corporate, is guilty of the offence and liable to be proceeded against and punished accordingly. 2, in paragraph 1, a reference to an officer of a body corporate includes a reference to A, a director, manager, secretary, or other similar officer, and B, a person purporting to act as a director, manager, secretary, or other officer. So Cameron, what's meant by consent, connivance, and neglect, and what's the difference?
Oh, well, I'm glad you asked. Consent, connivance, and neglect are different. Charges alleging director liability, in our experience, usually reference all three, and it is for the prosecution to prove the relevant mode of liability to the criminal standard. Taking each in turn, consent is when a director is said to know the material facts which constitute the offence and agrees with it. Importantly, they don't have to know that it's against the law necessarily, but they are well aware of what was happening and agreed with it. For example, a company importing unsafe child car seats from abroad, placing them on the market, and the director knowing when the company did so that they were unsafe and giving instructions to do it anyway. They are consenting, and that's a real case that we did when the director went to jail as a result. Connivance is similar to consent, but the agreement is tacit, not actively encouraging the criminal act of placing unsafe seats on the market in this example, but letting it continue and saying nothing about it. Perhaps you have evidence of emails being sent to the director informing them of the safety issue, and they do nothing thereafter. And then neglect, a failure to do something that ought reasonably have been done to prevent the offence. The question is objective and does not require proof that the individual knew that they were under a duty to act. Often it is useful, when dealing with a company director, to set out the legal duties of a director under the Companies Act, section 174 in particular, to exercise reasonable care, skill and diligence in their position as a director. But more importantly, you need to establish that the director was responsible for the business or part of the business that was at fault. It has been argued in the courts that including all three ways in which a director might commit the offence is duplicitous, but that was rejected by Lord Justice Auld as long ago as 1997 and is, in our view, unlikely to gain any traction today. Nevertheless, it is arguably good practice, certainly by the time of trial, to eliminate a mode of liability that will not be advanced as part of the prosecution. In other words, if the evidence doesn't reflect consent, don't particularise consent. We are coming towards the end of this whistle-stop tour of corporate liability, but want to end, as we said we would at the start, with pitfalls and tips. So Sabrina, first pitfall?
Yes. The first, and arguably most important, is charging the correct defendant. A good example of this could arise in the context of a neglect charge. Careful consideration needs to be given to whether you've identified the director with responsibilities in the area in which the failings took place. It is not the case that mens rea, so the mental element, can be inferred against any director regardless of their role. So the first question in that scenario is whether the director had any responsibility in relation to the part of the business that was at fault. If they don't, you need to look for another individual. The issue can also arise when large companies have very complex corporate structures. You'll remember all those corporate diagrams where you see the interrelationship between companies. Care really does need to be taken at the start of an investigation to understand that structure and who is responsible for what. This pitfall is particularly important given the difficulties amending charges to change the identity of a defendant, and can be particularly devastating when time limits are at play.
So in part, getting the name of the company right.
Yeah, exactly.
The second tip or pitfall is not checking the status of a company. Proceedings, including criminal proceedings, may not be commenced against a company in administration or against a company with a winding up order, or where a provisional liquidator has been appointed without the leave of the court dealing with the insolvency proceedings. If you're investigating with a view to a possible prosecution, you should make sure you apply to prevent the company you're investigating being dissolved and struck off. You can apply, of course, to restore a company to the register if it has been struck off, but it's much easier to prevent it in the first place. Dissolution of the company has the same effect as the death of a human defendant, inasmuch as the company will cease to exist, and you can't prosecute it if it doesn't exist.
The third pitfall, and a personal bugbear of mine, is failing to recognise that a company and its directors are separate persons. We most frequently see this problem when interviews are conducted or consultations undertaken. If we look at interviews, an individual, usually a director, provides responses to interview questions, usually in writing where you've got a large company being involved, but it's not clear in what capacity those questions are first being asked and then second being answered. So when interviews take place, either in person or in writing, do make sure you clarify the role in which the individual is responding to the questions. Is it in their capacity as an officer of the company, on the company's behalf, or is it in their personal capacity? And indeed, they may answer the same set of questions in both sets of capacities. So just be clear that you know which one the answer is given in.
The fourth we've briefly touched upon earlier. Don't fall into the trap of concluding that what you've investigated is a strict liability offence attributable to a company and therefore leaving it at that. There is a duty to follow all reasonable lines of inquiry, and that includes assessing the steps taken by the companies to avoid the commission of the offence or offences. A failure to undertake this step may mean you fail to properly apply the full code test, failure to properly assess the realistic prospects of conviction, and could find yourself on the end of abusive process arguments, even judicial review of your decision to prosecute, and potentially wasted costs applications. It may sound trite and obvious to follow the possibility of a due diligence defence, but we've both been in cases where the merits of a due diligence defence have not been properly considered, and certainly when defending them we've had to make robust submissions about the same.
Tip 5. Usually you'll see a company prosecuted alongside director when consent, connivance or neglect provisions are relied upon. That makes good sense, as the underlying offence by the company has to be proved before reliance can be placed on the consent, connivance and neglect provisions. But there are situations in which the company may fall out of the picture, if they're liquidated, for example. In that situation, it can be very easy to forget that it is essential to prove that had the company been prosecuted, it would have been found guilty of the offence to which the director is said to have consented, connived or neglect.
You've got to prove it against the company in every situation.
Yeah.
Well, there are 5 quick tips. More can be said, and perhaps when we see some of you next, which we look forward to, we can chat more. But that's it for now. It is, however, worth watching this space, as there are developments afoot in relation to corporate liability. We will soon be seeing a new offence in the Economic Crime and Corporate Transparency Bill of failing to prevent fraud, where organisations will be liable for fraud offences committed by its employees or agents for the organisation's benefit. They will be guilty if they did not have reasonable fraud prevention procedures in place. So, large organisations, beware. Anyway, thank you for watching. We hope it was useful, but if there are any questions, please do get in touch and we'll do our best to try and answer them. But for now, bye-bye.
And bye. Thank you very much.